Hi, everyone. It's great to be back with you. It is September 20th. We are inches away from the fall officially here in New York City in Midtown. It is busy. The UN General Assembly is back for the first time in 3 years, and there are cars moving this way and that all throughout the area where our office is. It is another sign that we are coming back to something approximating normal, or whatever it is that we're calling this new understanding of how we move forward. But we're here, as always, to give you a sense of what we've learned this week and what you should know. I'm excited to share the floor with three of my colleagues, one down the hall from me here in New York City, one as well in Albany, and another in Syracuse, and I'll tell you a little bit more about them in a moment. Excuse me. So Kathy, if you could please go to the next slide, I will walk through the agenda and let everyone know what we're intending to cover today. To begin, I'll provide you with some updates on COVID and other public health information that we have, just to keep you all current. And then Sam Dobre, who's down the hall, as I mentioned, is going to be speaking with you about another New York City issue in the context of some state law, essentially the gun-free zones in Times Square. And this all comes in the context of new concealed carry standards that emanate themselves from the Supreme Court activity earlier this year. Then we'll move to Delaney Knapp, who's back on the webinar. She's presented a number of different times from our Albany office, and Delaney is going to be walking through e-filing requirements that are in place from the Charities Bureau and germane to nonprofit organizations. And then from Syracuse, we'll have Gianelle, as I mentioned, also back with us, and she is ready to tell us about a proposed rule from the NLRB that would expand the scope of joint employment. But before we get to their presentations, let me walk through a few remarks that I mentioned I would make. And why don't we go to the next slide, please, Kathy, and I can let everyone know what is happening with COVID. Nationally, the numbers are definitely dropping. There is no way to suggest otherwise, based at least on what we can measure. As I've mentioned here before, the public health data is different than it used to be. There are not a whole lot of PCR tests getting in the hands of public health officials. There's a lot of home testing. It's not all very well tracked. But based on what we do know, we're seeing about a 27% change over the last 14 days in the direction of lesser COVID prevalence. All good news. And of course, President Biden declared in a 60 Minutes interview that's been very much talked about since, that the pandemic is, President's words, over. Of course, that has been met with public health officials and others questioning whether that is indeed the case. But what I think more broadly it signifies is that we're in a stage that is different than if you and we were to be talking about this in September of 21, for instance. It is a stage where we are living with the virus, where people are moving on with their activities and lives, and that's really what the president's sentiment was intended to convey. So why don't we move to the next slide, please, and we can talk a little bit more about what we're seeing around the country. Thank you, Kathy. You'll see that there are fewer of those darkened areas that are concerning. Those are the ones that, back just around Labor Day when I was with you last, were locust in the Mid-South and otherwise in places like Texas and Oklahoma. We're now seeing a whole lot less of that across the country, which is certainly another way to depict that significant drop I noted a moment ago. So let's go to the next slide, please. In New York State, however, we are seeing an uptick, and it's actually a pretty pronounced one. It's 42%. I can tell you on a personal note, I had a kid who contracted COVID just within the last 10 days. It's certainly circulating and around schools as well. And there are a lot of people who are certainly experiencing COVID. And in New York, I think any of us who lives here knows plenty of people who are working through infections or otherwise. So it's definitely present, and the data that we do have, really tell that story. And that, of course, though, has come in the context of the governor, however, saying, really much in the same spirit as the president, that the executive authority around the pandemic, where the governor had emergency powers to exert, ones that essentially she reasserted last year during what were elevating indications of COVID all around the state. The governor has allowed those to sunset. And so we are living in a moment where the governor is not utilizing essentially additional executive authority to manage the pandemic. And that's an important counterpoint relative to that growth I just mentioned in the overall numbers. Next slide, please. And in New York City, here we no longer have a mask mandate on the subways and other mass transit. I can tell you it wasn't terribly well enforced for a long while. This just brings reality into alignment with the standards. But there are plenty of people who are and who are not wearing masks, and that is essentially where we are. There's a lot of personal discretion and choice in these matters. What we also know is that Mayor Eric Adams has indicated informally and otherwise through his administration, but we should see something more formal imminently, that the private sector workplace mandate will be sunsetting. That's one you may recall, for those of you with activity in New York City, that would have applied to about 184,000 businesses. Indeed, it did, had it been enforced, but the mayoralty changed, and when Mayor Adams came in, he made very clear that it was not a set of standards that he saw as ones his administration would stand behind in the same way, and the administration will allow that schema to sunset formally in the near term, and we'll keep you posted when that does happen. Why don't we go to the next slide, please? So if you look at the 2-week differentials in New York, which is something that we regularly bring forward to you, what you'll see is, again, that 42% bump up. And you're seeing it in basically every county. There's a lot happening in terms of numbers that we can track. And we'll continue to monitor all of this. But the experience on the proverbial ground is that, life goes on, and while people are contracting COVID, they're, for the most part, able to recover quickly. And so we're grateful for that, I will say personally, and know that as we're in this time of change, we'll continue to keep all of you updated. Next slide, please. So as we've talked about, if it weren't enough with COVID, we're also contending with monkeypox and polio. On polio, the governor, around the same time, the governor made the decision to step away from essentially the executive authority around the COVID mandates. Now we're seeing the governor, though, say that polio requires that level of executive discretion, and there's an emergency order, executive order, in place. And you can see it reproduced here on the slide. Ongoing monitoring of both types of pathogens very much underway at all governmental levels, and we will keep you apprised. It's certainly a time where they're moving targets with both of these, and as they may affect your workplaces, let alone employer responsibilities, we'll keep all of you in the know. So why don't we then please go to the next slide, if you would, Kathy. And it's an opportunity for me to introduce Sam. Sam Dobre is an associate here in New York City, as I noted, sits down the hall from me here, and is a graduate of the Cardozo Law School, and also attended SUNY Binghamton. So very much a New Yorker, one who has a lot to share with us. He has a practice that's involving complex labor and employment litigation, wage and hour class actions, and employment discrimination, retaliation. That's just some of what keeps Sam busy. And what he's here to tell us about, as I mentioned, is what we can say about the gun-free zone standards in Times Square and how that fits into this broader new state paradigm resulting from the Supreme Court's activity earlier this year and New York State's response to that. So Sam, the floor is yours, and thank you so much for taking the time to be with us and to educate our audience.
Of course, thanks for the introduction, Gabe. I got some recent developments here in New York, and no, I'm not talking about the Yankees, the Mets, the Giants, and the Jets all winning on the same day on Sunday for the first time since 2009, but I'm here to talk about the concealed carry law in New York. So for those of you who don't know, in June of this year, the United States Supreme Court issued a historic ruling in a case called New York State Rifle and Pistol Association versus Bruin, which invalidated a century-old provision of New York's concealed carry law, which required applicants to show proper cause in order to obtain a license to carry a concealed handgun outside of their homes. In this case, the court held that the provision violated the 14th Amendment and that it prevents citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms. The Supreme Court held oral arguments for this case back in November of last year. And the plaintiffs in this case were challenging the 100-year-old New York State handgun licensing law, which requires individuals to show proper cause before they can be licensed to carry a concealed weapon in public. The plaintiffs also argued that the law violates the Second Amendment. Defending the handgun licensing law, New York argued that the right to carry a weapon for self-defense outside the home is not absolute. So the court ruled that New York's concealed carry law is unconstitutional, which did extend the right to own a gun for self-defense in the home and outside the home as well. The court distinguished New York's law from other gun safety regulations, including requirements like background checks. And as a result of this case, and due to the new concealed gun laws, employers should start to consider whether they want to allow guns on their premises, and if so, posting clear and conspicuous signage, or otherwise providing express consent to any visitors, guests, patrons, employees. Now here in New York City, and following the court's decision, there are New Yorkers who braced for a possible wave of increased violence. Crime reports here in New York in the last few months in New York City, New York Police Department data shows an 84% spike in major crime when compared to 2021 crime rates. And a lot of business owners here in New York have been particularly frustrated in the city as increased violences continue to place a strain on their business during a time when many businesses are still in fact recovering from the COVID-19 pandemic. And as a result of this case, and in light of any growing concerns about public safety in New York after the Supreme Court decision, the legislature pretty promptly drafted a Concealed Carry Improvement Act, which was signed by the governor. And the new law, which became effective on September 1st, limits who can carry a gun carry permit and a lot of other limitations, how to obtain a permit, restrictions on where guns may be carried. It effectively prohibits guns in certain sensitive places, which, for example, are government-owned buildings, educational institutions, healthcare facilities, places of worship, or any place where alcohol is consumed, and public transportation as well. The new law, the Concealed Carry Improvement Act, establishes additional limitations and new eligibility requirements for those seeking concealed carry permits, and also an expansive disqualifying criteria. So what it does is it requires an interview with a licensing agency. It requires firearms safety training. It requires certain and specific storage requirements for gun in vehicles. It includes, you have to provide a character reference and submit a character reference and a background check. That includes providing a list of social media accounts. Their licenses will only be granted to people with quote unquote good moral character and not issued to people who have a history of violent behavior or recent convictions for several crimes, including assault, menacing, or driving while intoxicated. And as Gabe mentioned before, one specific location in New York City's Times Square, which everyone knows as the commercial entertainment destination here in Midtown Manhattan, is now considered a gun-free zone. Times Square was declared a sensitive location, and the New York City Council proposed boundaries for this gun-free zone to extend from 6th Avenue to 8th Avenue here in the city, all the way from West 40th Street to West 53rd Street. And as you're walking through New York City now, you'll probably start to notice signs that say gun-free zone. They're now placed at every entry point into specific gun zones. And Times Square will certainly not be the only sensitive area in New York City with restrictions. Like I mentioned before, subways, schools, and other locations are going to be designated as gun-free zones as well. So one thing employers, especially in this area, are well advised to ensure employees of this restriction, make employees aware of this restriction. And as a precautionary measure, any employers throughout the state should consider posting signs that explicitly state whether or not guns are allowed on the property to make the presence of firearms known. A few recommendations in light of this decision and the gun carry law, which can supplement a company's standard policy prohibiting weapons. Like I said, posting a sign is one in a workplace, similar to the sign that's being posted throughout New York State. The New York State sign states a big gun-free zone. It states that licensed gun owners and others may not enter with a gun unless otherwise specifically authorized. And these signs throughout the city also state that a violation of this prohibition may be a felony. And then another recommendation for employers now is amending any standard policies and employee handbooks to include this same language, if not already in there, that violation of the policy and the law will lead to discipline up to and including termination. So that's the update on the gun-free zone, and I'm going to turn it back to Gabe.
Sam, thank you very much for taking the time to bring us up to date, and in particular for helping us think about what are some of the applications in the neighborhoods we walk through and otherwise the businesses that we engage with. This is a time where we are going to be seeing lots that's changing. And so we're glad that you could bring us up to speed on essentially what it is to live with these new standards. And so with that, we're going to shift gears and we're going to bring forward Delaney Knapp. We are delighted that Delaney is back with us. Delaney sits in our Albany office, as I mentioned, is a graduate of Siena College as well as Albany Law School, and really devotes her time professionally to nonprofits and other exempt organizations at each phase in their life cycle, and is very much conversant on these e-filing changes that I alluded to, and is going to walk us through what they mean for the organizations in New York State that need to pay attention to them. So Delaney, thank you in advance. Looking forward to learning.
Thank you, Gabe. I just wanted to briefly note that I think Albany is having some internet connectivity issues. So if I go out, I apologize. Go to the next slide, Kathy. So just as a brief overview, this is mainly applicable to not-for-profit organizations, those who are working for them or running them, but also if you're someone who just serves on a board of a nonprofit, this could also be very useful information for you. So just starting off, if you are on the board of a nonprofit or if you run one, you know that charitable organizations are required to be registered with the New York State Attorney General's Charities Bureau. And so these are organizations that are conducting charitable activities, holding property that's used for charitable purposes, or soliciting financial or other contributions within the state of New York. And that includes grants from foundations as well as government grants. Not every charitable organization is required to be registered. So there are some exemptions, mainly for religious organizations like houses of worship, or other charitable organizations run by religious organizations, as well as some educational institutions, colleges, universities, entities like that. Next slide, Kathy. And so while registration is required, there's also an annual filing requirement that is mandated as well. The form is called a CHAR 500. And depending on the size of your organization, the assets you have, you may also have to attach a copy of your annual IRS filing. So the Form 990, EZ or PF, and then potentially an independent certified public accountants review or audit report if necessary. And then sometimes there's a filing fee. Next slide. And so previously, these forms have been filed by paper, so you would fill them out by hand. You would have 2 signatures by hand, and then you would mail them in, and it would take, I think prior to the pandemic, maybe a couple months to process. Since the pandemic, the paper filings, there's like an incredible backlog. And so it's been really difficult for the AG's office to manage getting through the backlog, making sure that the reports are correctly filled out, and getting them up on their Charities Bureau registry so that the general public has access to this information and can review the documentation submitted by charities. So they started moving to an e-filing system. This has been available for several months. So it's something that I've been using regularly with our clients just because I find it incredibly efficient. And so has the Charities Bureau. In their announcement saying that we would be moving to this mandatory use of the system starting the 19th, so yesterday, they published that they have found it's streamlined their annual filing process, it's minimized their review time of the reports, and it's reduced errors and incomplete annual submissions by nonprofits. Because sometimes the forms, when you're trying to read them, there's different rules for different types of organizations. It can be a bit confusing, and the electronic system does a really good job, I think, of walking you through each step. You can't move on before answering a broader question, things like that. And through assisting our clients, I've also noticed that using the online system significantly reduces the time for approved filings to be posted. So we'll submit a report. The AG's office usually reviews it within a week or so, and then it's up on the registry within a couple days after that, which is a significant difference. Next slide. So there's a couple specific requirements that are unique to the e-filing. The form is essentially the same, so it's going to be how you've been completing it for past years. But your first time going in, you're going to need to create an account. And then once you create your account, you'll enter in your 6-digit New York State registration number that's associated with your organization to begin the filing. And this number can be located on any previously filed Char 500 that you've submitted, or you can search your organization's name on the registry and that number will pop up. Next slide. So this is what the registry looks like. If you've never been on it, this is also a great resource for donors to learn more about organizations registered in New York State. But you would go in and you can type in your organization's name down there, and it'll pop up with a page, and it has all the relevant information, their past filings. Typically, it has their certificate of incorporation, sometimes the bylaws, or the IRS determination letter if they're a 501c3 or 501c4 as well. Next. Okay, so then as you would with the paper filings, you also are going to be submitting your supporting documentation through this online system. So all the same types of documents, your IRS filings, any accountants reviews or reports, those are also going to go up there. If you've changed the name of your organization and you file the certificate of amendment, that will be uploaded as well. There's a separate section for you to upload each of these files. They have to be in PDF form, and each file has to be under 10 megabytes. Next slide. And this is probably the most significant change in where I've seen clients have to adapt the most, although I still think it's very efficient. So previously, as you know, you had to have 2 signatures on these filings. One was from a president or other authorized officer, and then one had to be from a person with fiscal responsibility. So typically it was a CFO or a treasurer. And you would have them each sign by hand and mail it in that way. And now you have to have, you insert their email address into the online system, then the system will send an email out to each of them individually. They'll log in, I believe it's through DocuSign. So they'll click on a link, and then they insert in their electronic signature. And then once both have signed, an email comes back to the preparer. So in my circumstances, I would get an email back from the system saying that both signatures have been submitted. And then if a filing fee is required, then I can go in and pay that, or the preparer would do that as well. So there's a little bit of back and forth. Multiple parties have to engage with the system, but I think they do a pretty good job of making it user-friendly. Next slide. So in terms of ongoing compliance, and this is just a reminder I wanted to put out there, the efficiency of this system also allows preparers to quickly bring organizations into compliance with past due annual filings. So if you're checking out your organization on the registry for the first time and you're noticing that, maybe you're on the board of a very small nonprofit and this is something that slipped your mind with the pandemic, definitely happened for many people. But with the online system, if you've missed filings for 2019 and on, you can just go log in. When you put in that 6-digit number of your organization, it'll ask you which tax year you're filing for. You can file for 2019. As soon as that's signed and submitted, you can go right back in and do 2020, one after another. The AG's office will review them one after another. So you can quickly bring your organization back into compliance if it's out of compliance. If you are missing filings for 2018 or earlier, you'll have to still either submit them through hard copy filings up to 2018, or you can also use this form990.org, which is also available. Next slide. And this, I just wanted to give you an example. When you go type in the name of an organization, this is what's going to pop up. There'll be some brief information at the top with the name and the address and things like that. And if you scroll down, you can see down here when the filings were made. And so this organization is in compliance right now, but if you saw, 2021 or 2020 was missing, you could go in online and bring your organization back into compliance. Next slide. And that's it for me. So if anyone has any questions, either using the system or about the annual Chart 500s, feel free to let me know.
Thank you so much, Delaney. Very helpful information, particularly as you point out, not only for nonprofit organizations, but also for those individuals who in their personal lives choose to give service to boards and who want to be able to get good information quickly. And so those are great resources that you pointed the viewership toward, and I thank you on behalf of those tuning in for that. What we'll do now is we'll shift to Janelle, who is back with us and sits in Syracuse. What I wanted to focus on is her educational background. She's Syracuse trained through and through, including as an undergrad as well, the law school, and has been with Bond working on a range of labor employment matters, including employment relating contracts and policies, and a broad array of issues that have come across her desk since she's been with the firm. And she's here today to tell us about the NLRB and the proposed rule that would expand the scope of joint employment. This will be really informative, I'm confident, and we're really further delighted that you're back with us to provide this kind of learning for the audience. Please, the floor is yours.
Thanks, Gabe. So as Gabe mentioned, today I'm going to be discussing a recent and potentially very significant development related to the joint employer standard under the National Labor Relations Act. So 2 weeks ago on September 6th, the National Labor Relations Board released a notice of proposed rulemaking. And this proposed rulemaking would revise the standard for determining joint employer status, which has been in effect since April 27th of 2020. Now, the joint employer standard is pretty controversial, and the standard has frequently changed and been debated, and these changes can largely be attributed to the composition and political control of the National Labor Relations Board. Now, in its notice of proposed rulemaking, the board stated that its main intention for these changes are to explicitly ground the joint employer standard and establish common law agency principles consistent with board precedent and rulings from the U.S. Court of Appeals for the D.C. Circuit. Now I'm going to provide a little bit of background on how this joint employer standard has changed, specifically from employee-friendly to employer-friendly and back and forth throughout the years, and then bring us up to speed on where we are at today with this proposed rule. So in 2015, the board issued a notable decision called Browning-Ferris. This decision solidified a joint employer standard that broadly expanded the definition of joint employer and overturned years of labor law precedent. So under this Browning-Ferris standard, an employer was considered to be a joint employer if that employer had either direct or indirect contractual right to control any terms and conditions of an employee's employment. Now, this decision went beyond the prior standard that had been in place for decades, which originally required the putative joint employer to exercise actual control over the essential terms and conditions of employment, with that actual control being both direct and immediate. The board additionally identified this non-exhaustive list of essential terms and conditions that an employer must assert control over in order to be deemed a joint employer under the rule. And as a result, this broad standard led to a dramatic increase in the universe of potential joint employers, which then I'll talk about later, resulted in some serious implications and consequences. So the board then shifted towards a more employer-friendly version of the joint employer standard with the adoption of its current standard. So that standard that's been in effect since April 27th of 2020. Under the board's 2020 rule, an employer is considered to be a joint employer if that employer shares or co-determines the employee's essential terms and conditions of employment. This is in direct contrast with that Browning-Ferris standard I just discussed from 2015. So the board, under this 2020 rule that's currently in place, no longer considers indirect control over an employee's terms and conditions of employment when analyzing joint employer status under the current rule. The board further limited that list of essential terms and conditions that an employer must assert in order to be deemed, assert control over in order to be deemed a joint employer. So it made it into an exhaustive list and limited it to include wages, benefits, hours of work, hiring, discipline, discharge, supervision, and direction. And only these are the essential terms and conditions that are considered in this analysis. So under this current 2020 standard that we operate under, an employer is less likely to be considered a joint employer because the board requires a higher standard of substantial, direct, and immediate control over employment terms. So we are, just to summarize, we're operating under this current 2020 rule that went back before the Browning-Ferris standard, where it's just this direct and immediate actual control over these essential terms and conditions of employment. And then prior to this current rule, it is the analysis considers both direct and indirect control. So now this brings us up to present day. The board's new proposed 2020 rule seeks to replace the 2020 direct and immediate control standard with a less demanding legal standard. The new rule would reject the 2020 rule's focus on direct and immediate control and would restore the Browning-Ferris indirect reserved standard. So under the proposed rule, 2 or more employers will be considered joint employers if they share or co-determine those matters governing employees' essential terms and conditions of employment. The board defines share or co-determine to mean for an employer to possess the authority to control, whether that be direct, indirect, or both, or to exercise the power to control, whether direct, indirect, or both, over one or more of the employee's essential terms and conditions of employment. So again, we're seeing this broad expansion of the definition of joint employment. Similar to this Browning-Ferris standard from 2015, in analyzing joint employer status, the board proposes consideration of both direct evidence of control and evidence of reserved and/or indirect control over these essential terms and conditions of employment. As such, an employer's indirect or unexercised authority to control these terms and conditions of employment would be enough to find joint employment exists. Additionally, with that exhaustive, non-exhaustive list of essential terms and conditions, the new rule would expand that 2020 rules non-exhaustive list of terms and conditions to include more terms and conditions. So they would now be wages, benefits and other compensation, hours of work and scheduling, hiring and discharge, discipline, workplace health and safety, which has never been included before on this list, supervision, assignment, work rules and directions, governing the manner, means, and method of work performance. So again, we're just seeing this expansion back to this employee-friendly rule from the current more employer-friendly rule. So although the joint employer rule is constantly transforming based on this different composition of the board as it changes, it's critical for employers to remain updated on these changes because an employer's joint employer status has the potential to have serious implications and consequences. This is going to be especially important for employers that work regularly and closely with other entities, such as franchisors, contractors, and temporary staffing agencies. So that's mainly where this is going to come into play, and employers need to be updated on these rules. So some examples of the implications that can arise from joint employment status include a potential requirement to bargain with a union representing these jointly employed workers, or potential shared liability for violations of the National Labor Relations Act. So again, this rule is still in the proposal stage. So at this point in the process, the board has invited the public to comment on all aspects of the proposed rule until November 7th of this year. And then replies to comments filed during that initial comment period must be filed with the board on or before November 21st. So we will be sure to keep monitoring the status of this proposed rule and provide any updates as they come along.
Thank you very much for that informative presentation. Yes, this is proposed, but it clearly would be significant in its impact if everything as architected were to move forward. And so having some advanced understanding is critical for so many of our clients. And so, Janelle, thank you for providing that. And with that, let me take this opportunity to ask if, Janelle, you know whether the NLRB proposed rule has any effect on quote unquote leased employees, which is something that I think a lot of organizations will want to know.
So I have not seen anything specifically with respect to leased employees yet, but I'm sure it's going to come up and there's going to have to be some discussion about it, especially after the comment period.
Okay, well, we'll stand waiting for more information, and really glad that you'll be tracking this for us. And so thank you for taking this time. And of course, please come back, whether after that close of the comment period or otherwise to keep us up to date. And so with that, let me make sure that we're able to take all of the questions that you may have. We've been answering them along the way in the chat, and I don't see anything currently popping up. So what I'll do then is, thank you, Kathy. I was going to ask you to bring up that slide where you can, if you're participating here on your computers at your desks, click through and contact any of us if you have questions about our presentations. We really, as always, are hopeful that this is a way that you learn and stay connected to all that is changing in our legal and regulatory environments that affect you as our community of employers and others that care about what we have to share here. So keep tuning in. I'll be back with you in 2 weeks. And if anything else comes up in between, please don't hesitate to reach out. Thank you again. Stay safe out there and enjoy as we cross into fall.